Oh, we've got the war still raging between lower courts and the United States Supreme Court about precedential value, the concept of stare decisis, which is the basis of our entire court system in America. We are not a civil code system. We don't just look at a statute book and let a judge on their own come up with their own interpretation, and then it starts all over again in the next case. We are supposed to allow for appellate courts to make rulings up to the United States Supreme Court and for lower courts to follow those rulings in our concept of precedent. But the whole wheels have fallen off the wagon. You've got a United States Supreme Court justice who, during a visit to Catholic University, I'm talking about Justice Thomas, just in the last 48 hours, said he doesn't even have to follow precedent. Precedent is not a gospel to be followed. At the same time, the Supreme Court is chastising senior and other judges because they're not following the Supreme Court's one paragraph emergency shadow docket rulings and not affording them precedential import or respect. Oh, they're taking much umbrage. Gorsuch wagging his finger at federal judges. Yes, it's only a paragraph, but it's our paragraph and you must follow it. Except when one of our justices says you don't have to follow it. And now we have Justice or Judge Lamperth, he should be Justice, Judge Lamperth, Royce Lamperth, who just in a ruling, just in the last 24 hours, took time out of his rebuke of the Trump administration, effectively inviting the plaintiffs to file a motion for contempt because of the wholesale destruction of the Voice of America led by Carrie Lake. But he took time out of that decision to go after the United States Supreme Court. I'm going to tie all that together right here on a hot take only on the MeidasTouch Network and on Legal AF. I'm Michael Popok. All right, you understand, or you should understand now that I've kind of given you the outline of it, the primer of it, that our system of precedent, meaning the case prior, the analysis prior, applies to the current case. Either you reason by analogy or you have to apply the law to the facts. That's the role of the judge. We call that stare decisis. Every case has a gravamen, which is sort of the ultimate at bottom rationale, a ratio decidendi, which is sort of the logical framework that got you to the bottom line. That's the logic, inherent logic of the decision, the facts, and of course the law. You put all that together, you hand it off to a lower court judge, and the lower court judge, based on that thing, then applies the precedent. But that's all upside down now. Let me play you the clip of, this is a sitting justice of the United States Supreme Court that in the comfy, friendly confines of Catholic University decided to let it rip and effectively say, I'm not following precedent that I don't agree with. Let's play the clip of Justice Thomas at Catholic University in the last couple of days. Roll.
And what that means sometimes for the concept of stare decisis. Do you see originalism and stare decisis as in tension with each other? And what factors do you bring when you write an opinion that suggests maybe a line of cases should be revisited?
Well, if I find it doesn't make any sense, I think we should demand that no matter what the case is, that it has more than just a simple theoretical basis. I don't think that I have the gospel, and I don't think that any of these cases that have been decided are the gospel. And I do give respect to precedent, but the precedent should be respectful of our legal tradition and our country and our laws, and be based on something, not just something that somebody dreamt up and others went along with.
Well, if that's how Justice Thomas, Mr. Originalism, we must look at what our founding fathers and framers said 250 years ago, because their dead hand is ruling this from the grave, apparently. Forget the living, breathing document that I learned about in law school. For the originalists on the MAGA 6 on the Supreme Court, the Constitution is as brittle as a fall leaf. It is trapped in amber, and you are not to disturb. You are to find a dictionary from the 1700s to define every word in there. I'm like, that's not what the founders wanted. that the founders wanted that to evolve either through amendment or through interpretation. But MAGA, ever since Robert Bork was rejected as a United States Supreme Court in the 1980s, and then Antonin Scalia got on to the Supreme Court, they have moved by each individual new justice added by a Republican, have moved further and further until they got to the point of a majority who believes in originalism, except when they don't. So their originalism leads them to reject precedent, which is the very foundation since John Marshall in 1807 gave the Supreme Court a job when he ruled in Marbury versus Madison. Even though it's not in the Constitution, so what do you do with that, originalists? This is the role of the Supreme Court in our three branch system of government. See, I never get an originalist to give me the right answer on that question. I've asked them before. If you're an originalist, you believe every literal word, it's like the scripture, every literal word of the Constitution must be interpreted as the founding fathers and framers would have interpreted. That's what you believe. What is its original meaning? Well, then how do you explain that the United States Supreme Court and its role in our government is not defined in the Constitution, but yet that came from a Supreme Court precedent? Well, heads explode now. All right. Then you have, in the last couple of months, there's a decision that came out with Judge Young, a senior status judge in Massachusetts, very conservative, a Reagan appointee of all things, in his 80s. He made a decision about the National Institute of Health to stop defunding by the Trump administration on the grounds of DEI, anti-woke, going after LGBTQ plus funding and the like. And making his ruling, Judge Young ignored a decision about the Department of Education that dealt with funding, basically saying that that is not precedent because it was an emergency stay application with no guidance to the lower court, no logic, no radio, no gravamen, no way for us to piece together what was meant by it. How could that possibly be precedent? In other words, if you want precedent, Supreme Court, then give proper guidance to the lower courts. Give them the logic, the analysis, the law, and the facts so they can apply it to future cases if our entire system of jurisprudence is based on precedent. Gorsuch goes after Judge Young in his concurrence, and he says the following. This is from the National Institute of Health case from August. Lower court judges may sometimes disagree with this court's decision, but they are never free to defy them. Rather than follow that direction of an earlier case, the district court in this case permitted a suit involving materially identical grants to proceed to final judgment under the APA. See, there was a case involving the Department of Education. In the Department of Education, on a emergency docket, the court stayed and allowed the funding to be cut. Gorsuch says, see, you should have followed that. You have a funding case involving National Institute of Health. You should have known from our Department of Education decision that you shouldn't block that killing of the funding either. I mean, is that really fair to the federal judges? As support for its course, the district court, that's Judge Young, invoked the persuasive authority of the dissents in California and an earlier Court of Appeals case. That was an error. Unless we wish anarchy to prevail within the federal judicial system, a precedent of this court must be followed by the lower federal courts, no matter how misguided the judges of the courts may think it is. The district court stressed that the court there granted only interim relief, pending appeal, and a writ of certiorari. True enough, Gorsuch says, but this court often addresses requests for interim relief, and either way, when this court issues a decision, it constitutes precedent that commands respect in the lower courts. Look at that versus what Thomas said, which is, I don't have to apply precedent. Of course, decisions regarding interim relief are not necessarily conclusive as to the merits, But regardless of a decision's procedural posture, Gorsuch continues, its reasoning, its ratio decidendi, carries precedential weight in future cases that are to be ignored by the Supreme Court itself. Here's, now let's move forward to just in the last 24 hours. Here's what Judge Royce Lamperth said to his bosses at the Supreme Court, joining a growing chorus of appellate judges and lower court judges that are throwing up their hands and saying, look, you're going to run this country by emergency docket and shadow docket, allowing Donald Trump to grab the reins of power without being checked or balanced, and you're going to do that by way of one paragraph decision making. What do you think the lower courts are supposed to do with that? Here's what Judge Lamperth said, because in their case involving the Voice of America, Donald Trump said, oh, you can't block the reduction in force because there's these other cases in which reductions in force had been, which is firings, have been allowed by the Supreme Court in a couple of paragraph decisions, like for the Department of Education and 6 other administrative agencies. You have to apply that. You can't block us. That's not part of your powers under a preliminary injunction. Here's what Judge Lamperth has to say back to that, criticizing the Supreme Court. The defendants point to 2 stay posture cases in the Supreme Court that stopped RIFs at the Department of Education and 6 other agencies. In doing so, the defendants invite this court, that's Trump, to infer from those orders a blanket rule favoring RIFs in this posture. The court, of course, accords the utmost respect to the Supreme Court's stay posture rulings. See, he's got to do that ass-kissing and that genuflecting because Judge Young in Massachusetts got reamed by Gorsuch. He got reamed so bad that there's reporting that Judge Young spent the entire next hearing, the next time he had a hearing, just apologizing to the Supreme Court. So that's why you have this line here. We accord the utmost respect to the Supreme Court, yet any appellate decision cannot provide precedential guidance without a statement of reasons from which the court can analogize to the present facts. So here, this is effectively Judge Lamperth responding to Gorsuch saying, yeah, I don't see it as precedential. I don't see it as authority that I need to apply. To follow the defendant's Trump's lead here would in effect countenance letting the government fill in the blanks of the Supreme Court's emergency rulings, these one paragraph things, relinquishing the basic judicial task of deciding what the law is, and to infer an ironclad prohibition against preliminarily enjoining RIFs, meaning you can't stop trial courts from blocking reductions in force or firings pending further litigation with disregard the essence of equitable relief. See, judges sit in equity and judges sit in law. For law, judges can award money damages. They also sit in equity. In the old-timey times and in London and in UK, there's courts of equity and there's courts of law. They're separate. Here, we put them together. The judge has equitable powers and law and legal powers. Under equitable powers, that's where they can issue injunctions. They can do a lot of things in equity. They can order mandatory injunctions, preliminary injunctions, administrative stays. They can shape a remedy that it doesn't have anything to do with dollars as part of fixing the injury that's in front of them, temporary or permanent. And so that's why Judge Lamperth ends this section with equity is allergic to rigidity. In other words, I need to have the flexibility to fashion an order here, Supreme Court, and you're not helping me with your one paragraph decision making. Because it ends with, nor does this court believe the Supreme Court expects district courts to not use its equitable powers appropriately. Game on, right? That's Lamperth saying, yeah, you went after my buddy, fellow senior judge William Young up in Massachusetts. Here's my response. This call-in response that we're watching between lower courts and the appellate courts and the Supreme Court I don't even want to say it's unusual. It's unprecedented. It's never happened in the history. Not like this. This open warfare. We just had a hearing, the Fourth Circuit Court of Appeals hearing, in which, having nothing to do with this issue, the en banc panel, which is like 9 or more judges, went into an extended debate, public debate, in which they were basically chastising the Supreme Court. Like, what do you expect us to do? We'll follow the law if you give it to us, but you're spoon feeding us these decisions off the emergency docket, which are of no help. Help. I guess that's what they're trying to say. SOS. Help. And does anybody think it helps? You can leave it in comments. That at the very same time, Justice Thomas is saying, screw precedent. I'm Michael Popok. I'm glad you're here on the MeidasTouch Network and on Legal AF. Take a minute, hit the free subscribe button here. Slide over to Legal AF, the YouTube channel. Do the exact same thing. This decision by Judge Lamperth, so you can read it for yourself, and the ruling by Gorsuch, I'm putting up in Legal AF Substack for you to read. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.